A superfan falls in love with an influencer, they have a baby, and now he claims she's too busy chasing likes to take care of their child. Today, a judge is about to decide social media lifestyle can outrank parental responsibility, and trust me, this case gets heated fast.
You all may be seated. Okay, Miss McKinney.
Yes, Your Honor.
We're back.
Yes.
I hope we are in better spirits.
I am.
Okay, good. And we're not going to allow each other to press each other's buttons, right?
Correct.
This opening tells you everything about the emotional temperature of this case. The judge isn't just setting courtroom rules, she's trying to prevent a powder keg from exploding. When a judge has to preemptively say don't press each other's buttons, it usually means there's deep history, unresolved resentment, and very little trust on either side. And remember, this isn't a fresh breakup. This dispute is 9 years old. That time gap matters legally and emotionally. It raises questions about motive, timing, and credibility. Why now? Why not earlier? Courts don't ignore timing, especially when a child is involved. Already, viewers should be asking, is this about responsibility or revenge?
We'll
Okay,
see what she
ready.
does.
Okay, so we took the DNA testing, had all that done. Did you all have any problems with that?
No, none at all.
Okay.
This part becomes critical later, and most people miss it. Both parties confirm on record that the DNA testing process went smoothly. No objections, no concerns, no irregularities. That matters because once you acknowledge the process was fair, it becomes extremely hard to discredit the results later. Judges rely heavily on this moment. It locks in credibility. So remember this when emotions boil over later. The court will fall back on what was said before the results were revealed, not after disappointment sets in. Let me ask you this. If you trust the test when you think it helps you, can you reject it when it doesn't?
Okay, have the two of you had an opportunity to speak at all?
We've
No
spoken.
way. No.
Lies.
All right. Okay, we spoke for 30 seconds. That doesn't count. I didn't want to talk to you. You came up to me. I tried to end the conversation as quick as possible.
Your Honor, permission to speak?
Yes, ma'am.
That is not true. He called me and he asked me, he said, look, I don't know which way this paternity test is gonna go, but if you'll just let me put it on you one more time, we can smooth all of this out, blah, 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 all of that crap.
Oh, so that's a lot in 30 seconds.
Really?
No, that's not what I said, but
When he lies, he puts his hand up like that on his cheek.
Oh, okay.
Yeah, that's a lie pose.
And you
Exhausting,
found
Your
all that
Honor.
out in 72 hours?
I did.
Interesting. Okay.
This is where the case turns personal fast. Accusations of lying, body language analysis, hand gestures, even live stream poses are brought into the courtroom. None of that is legal evidence, but it does show emotional instability, which judges absolutely notice. Meanwhile, the father claims this case is about revenge, not support, and points to the timing 9 years later, right when he has a fiancée and another child. That argument isn't crazy. Courts do look at delayed filings critically. The longer someone waits, the more scrutiny they face over motive. This moment plants a seed in the judge's mind. Is this case about the child or about reopening old wounds?
So
you see how aggressive she is about this? This
I'm
is
just excited.
She doesn't need help for her daughter.
Just
This is
come on
about
with the
revenge.
results,
This
please.
is clearly about getting back at me and punishing me for not, I don't know, staying with her forever. I don't know.
Results, please.
but it's been 9 years.
I know it's been, odd timing, isn't it? Right when I have a fiance and have a son, that's when she chooses to do this? Isn't that kind of odd timing here, Your Honor?
I mean, the timing does seem a little interesting.
I just came to the realization that, hey, I can do it alone, but I don't have to do it alone. If he's taking care of his other son and his fiance, that's fine. I don't need him to take care of me or my daughter, but it would be the right thing to do. And that's what he's going to do.
And
If he's the father.
He's the father.
Okay, and you're sure of that?
Yes, Your Honor.
Okay, all right.
Here's where things get legally interesting. She frames this as a moral issue. If he's the father, he should do the right thing. But morality and legality aren't the same in court. Judges don't rule on feelings or fairness, they rule on proof. And DNA doesn't care about belief, conviction, or emotional certainty. It's science. Meanwhile, the judge subtly reins things back in, reminding both parties that no one owes anything until paternity is established. That distinction is crucial. Child support cannot exist without legal parentage. Period. Viewers should already feel the tension rising, because once those results are read aloud, everything.
All right, well, I mean, bailiff, we have those results.
Got your cashier's check. Because I don't want to
That's
personal
not
check.
nice.
Well, I'm just saying.
You can't say that to him yet, though.
Okay.
We
All
don't
right.
know if he's even going to be the father to pay child support.
I know.
But if you are indeed the father, I wouldn't recommend you make a payment today because the order would just be being signed today.
Is there an appeal process even if I am the father?
What would you be appealing exactly?
I don't think that based on the way she's been treating me and based on her selective choice of when to bring this issue up in order to, you know, harm my relationship with my family, I consider that a form of harassment. And I feel like I should be able to file maybe a restraining order, and that would prevent me from, if I had a restraining order against her, that would prevent me obviously from having to pay for her child support, wouldn't it?
What is that, a restraint?
No, that's not how any of that works. That was really creative though, but that's not how any of that works.
This moment is almost surreal. The father suggests that if he files a restraining order, he wouldn't have to pay child support. That's not just incorrect, it shows a fundamental misunderstanding of family law. The judge shuts it down immediately. Protection orders do not erase parental obligations, ever. But notice the judge's tone, firm but almost amused. She recognizes this as desperation, not strategy. This exchange also signals something important. The judge is confident in what's coming next. She's not debating hypotheticals because the facts are about to speak for themselves. And when judges get calm like this, someone is usually about to lose badly.
So let me go ahead and tell you what the results say.
All right.
Let's get it over with.
All
Drum
right.
roll.
All right. It looks like baby McKinney, because we can't say a child's name.
Right.
There is no probability he can be the father.
What did they say? What?
You hear that?
What'd you say, Your Honor?
You
Remember?
laughed at that.
Remember
No,
when you
I didn't hear.
Oh, let me say it a
I'm
little
the
louder.
only white person she's been with. Remember?
There is
Remember that?
no probability that he is the father.
This is the nuclear moment, and the reaction is explosive. Despite clear DNA results, she immediately challenges the legitimacy of the test, the lab, the paperwork, even suggesting conspiracy through an attorney uncle. But remember earlier, she already confirmed the test was fair. Courts don't let parties rewrite reality because the outcome hurts. And when she doubles down tattoos, 72-hour windows, physical certainty, the judge doesn't waver. Science beats memory. Probability beats belief. This is where credibility collapses. Once a judge sees someone refusing objective evidence, it affects everything they say afterward. Ask yourself honestly, if you ignore DNA, what evidence would ever be enough?
Okay, so first of all, no disrespect to you, but the letter looks a little sketchy.
Okay.
It wasn't in a
It's got
legal
writing on
size
it.
envelope.
That's why it's sketchy.
So, and I don't trust him because his uncle is an attorney, okay? And his
Okay.
uncle can do
What does
all
that have to
types
do with
of
anything?
stuff. You know what I'm saying?
Okay.
So I don't even trust that.
Wait a minute, I believe at the beginning, I asked you all how the test went.
I mean,
And
the
you
test-
said, wait a minute, hold on. You said everything went good, right?
And it did.
And it
That's what she
did,
said.
and it was fair that day, right?
Yes.
They swabbed her mouth correctly.
The person appeared to be wearing PPE and the person appeared to work, you know, for that service. And the test itself went well, but behind the scenes, Your Honor.
And it
a lot
appears
goes
that
on.
these results are directly from the testing place. And he's not the father.
He is the father. Let me tell you why. Let me tell you why, Your
Let
Honor.
me tell you not. No, he's not.
He's the father.
He's not. So you're gonna you're
lost.
going to argue with DNA testing.
Your Honor, he is the father. 72 hours. He has
He
a tattoo
is not
on his
the
private
father.
parts. He was the
He
only
is
one
not
there. I
the
know
father. He is not the father.
Show
How
me a
many
tattoo.
times do I have to say that? No, I don't want to see a tattoo. All I want to see was these numbers to see what the probability was going to look like of him being the father. He is not the father. Now,
That was
you
way too much, by the way.
You have a tattoo.
excuse me. You know what? I don't even see why you all need to be having a conversation right now.
I agree.
Can we
you
do a
are not the
retest?
father, which means that you will not be placed on any type of child support or anything today. Now, you, Miss McKinney, you do have the right to petition someone else who you may think is the father.
There is no one else, Your Honor. It was him. He has a tattoo on his private part. I was with him and the tattoo for 72 hours. I know what I felt. I know what I saw. Okay, it was him.
Well, there is a probability of something else, though.
Okay.
You were probably with somebody else, too, within that previous 72 hours.
Oh, Your Honor, you tried it.
There's no shade, just facts.
It's very possible. It's
So,
very likely.
How is it possible?
Because there were like 6 or 7, 8 hours stretches during that time where I didn't see you or know where you were. I don't know what you were doing. you know what, maybe I'll give you the benefit of the doubt. Maybe you don't even remember this other guy. It's possible with the rate you were going in those days. So I'm willing to grant you that you may not have been lying.
Man.
You may
Okay.
not have been lying about thinking that I was the only white guy you were with.
Well, just answer my question. Do you have a tattoo on your private part?
I have a birthmark that kind of looks like a bird. Maybe
No,
that's
it
what you
says
thought.
Mississippi long. Do you have that tattoo?
Okay,
No.
well, you know what? This is what we're
Never
about to
been to
do.
Mississippi.
This is what we're about to do. At this rate, we're not getting anywhere. I've already said what the results were, which means I'm dismissing this case. You are more than welcome to bring another case. And if his account is true that you don't remember, you can bring another case after that. But the court is here to assist you. So if there are no more questions and nothing further, which it shouldn't be, you all are dismissed.
Hell no, it shouldn't be.
Whatever. You got a tattoo.
So here's the final outcome. After 9 years of uncertainty, the DNA test conclusively ruled him not the father. No child support. No obligation. Case dismissed. The court made it clear emotions, memory, and belief cannot override scientific proof. The judge also left the door open for future petitions, but only if they're grounded in evidence, not assumption. This case is a powerful reminder that courtrooms run on facts, not feelings, and denial only weakens your position. If you found this case as shocking as we did, hit like, drop a comment, and subscribe for more courtroom breakdowns.